Okay, my name's Kevin Diamond and I'm on the mock trial board, and I'm so excited to be here to talk to you about cross-examination. Yesterday I spoke for 2 hours to a group of about 40 attorneys about civil litigation and pretrial practice, and all I could think of the whole time is I can't wait to talk to some high school students tomorrow who are going to care about something I'm saying because they slept through everything I said yesterday. So I'm pretty pumped to be here today. Okay, so let's talk about cross-examination. Cross-examination is hugely important, especially in this tournament. And the reason is because it's chock full of points for you. I know that we're here to learn. We're here to learn about trials and law and to have an extracurricular activity. But as Judge Barker said when we talked to the judges before, you want to win. Part of this is really wanting to win, and if you want to win, you got to find places to get points. Direct examination is nice, and everything that Stephanie said is right on point, but you're not going to get tons of points in direct examination because it's just going back and forth. It's a little bit of memorizing. You do have to have character. You do have to listen. I agree with everything she said, but on cross-examination, other than when you're dealing with objections, it's really the only time you're going to have an unprepared discussion. So it's the only time that you're going to have to think on your feet and be able to respond. As judges, as scoring judges and presiding judges in the tournament, we're really looking for that. And when it comes time, if you're on the fence about, oh, am I going to give them a 6 or a 7, that is what's going to make the difference. Can you think on your feet? Because everybody can read the direct examination. Every now and then you will have your really strong witnesses. You'll have your attorneys who are very professional, don't need any notes and all of that. But when push comes to shove, it's the attorneys who can think on their feet, who can respond, and you know it wasn't prepared. All of a sudden they say something and you're like, wow, that was a good idea, or that was a great response. So cross-examination is going to be huge in this tournament. When you're practicing for your cross-examination, especially when you're practicing with your witnesses, you want to mix things up. And you want to make sure your witnesses mix things up so you're ready for crazy off-the-wall answers. For you coaches, honestly, tell your witnesses sometimes to throw in an answer that makes no sense at all. So where were you on the night of the 15th? Jelly beans. Whatever they have to say, just so you know that the practicing attorney has to think on their feet. What do you say to that? Excuse me, did you just say jelly beans? You want to be able, whatever gets thrown at you, to make that point, to make that change. You got to be creative. Stephanie Barker just talked about the fact that you're going to be doing the same thing over and over and over. And I guarantee you, by the 3rd or 4th round, you guys are going to be starting to get tired. And the judges are going to start to get tired because we hear the same thing over and over. And you try to put your happy face on, but that witness is coming up again, is going to talk about accident reconstruction and going to talk about how that person ran the stop sign, and it's hard to stay awake. Cross-examination is a good way to wake people up. And the best way to wake people up on cross-examination is don't have the same cross every round. You don't need to do it the same every time. One of my favorite things to do on cross-examination in what I'll say is real life, in a courtroom or even in a deposition, is to throw the ultimate question first. And you can do that. You don't have to go in the same order every time. So let's say your case is about whether somebody committed murder. And typically in cross-examination, you're going to start and you're going to say, now, that gun was yours, wasn't it? Yes. And isn't it true they found your fingerprints? And the person who's testifying, the witness, knows those are the questions that are coming first. So maybe in the 3rd round, you stand up, you don't even say your name, you don't even say the first question, you just stand up real calm and you say, you killed that person, didn't you? And all of a sudden that witness is like, whoa! And I've actually done that in a deposition before where I knew that the witness was prepared for the first question to be, tell me your name, what's your address, blah, blah, blah. And I just calmly sat down. I didn't even look at the person. And I said, you ran that stop sign, didn't you? And they went, no, I swear I didn't. But anyway, change things up. So when you're preparing your cross, don't just do it the same way every time, especially in those later rounds. Okay, basics of cross-examination. I guess the easiest thing I can say is it's the opposite of everything you just heard for the last half hour. But that really wouldn't be fair if I didn't describe it to you. So, direct examination is open questions, just like Stephanie Barker just talked about. So, where were you on the night of the 15th? What were you wearing? What time did it happen? How did that accident occur? It's questions that are open that call for an explanation. Okay, that's an open question. All right? You really can't answer it yes or no. If I were to ask you, what time is it? You wouldn't say yes, right? Because it's an open question. All right? That's what you do on direct examination. In fact, on direct examination, you cannot lead. So you're not allowed to say, it's 10:05, isn't it? That would call an objection. Okay? But on cross, it's completely the opposite. You're only asking questions that are going to call for closed yes or no answers. All right? Do not. Well, let me give you some examples first. So, it's true it's 10:05, isn't it? Yes. We're here at the high school, right? Yes. You want to hone those questions in so that it's a yes or no answer. Okay? Do not, I'm going to repeat this again, do not let the witness retell their story. Okay? On direct examination, the witness gets to tell their side of the case. They get to tell their story. They get to say what they want to say about the issue, about the case, about the incident. If you let them do it again, the jury, or here the scoring judges, are going to get twice. They get 2 bites at the apple. So if the plaintiff, I'm not sure what kind of case it is this year, I guess I should have read it before this morning, but if it's an auto accident case and the plaintiff gets to talk about the fact that the other car smashed into their car and how injured they are and how bad they feel and et cetera, you really don't want, as the attorney on the other side, to let them have the ability to tell it again. So the worst thing you could do is to stand up and say, you know, you just talked about an accident. Why don't you tell us again a little more just about the main points of that accident, as though you're changing it up. Well, you're giving them 2 bites at the apple. You're on the other side. Okay? When you're on the other side, you don't want to give them that second bite of the apple. You want to take away as many bites as you can. So don't ask an open question. Don't let them retell their story. And a good witness, for those of you who are going to be coaching and preparing your witnesses, are going to try to retell that story. You're going to try to weave your answers so that when I say, well, isn't it true that you struck into the back of that, or that you collided with the back of that car? And instead of saying yes or no, the good witness is going to say, well, it is when they were backing up into me. You want to get that out, and then the attorney's got to find a way to deal with, live with, change that up. Okay? But, that's the little chess match that goes on. But don't let them retell their story on cross. Okay. Getting nuggets for closing argument. That's really one of the main things you want to do for your cross-examination. And remember, it's the opposite of what Stephanie just talked to you about. On direct examination, the witness is testifying. Okay, what the witness says is the story, because all you're doing as the attorney is saying, how did it happen? What happened? On cross-examination, the attorney is telling the story. You are the star. So when you're writing your cross-examination, when you're thinking about the questions to ask, what you should be thinking about is, what points do I need to get out? And it's not just what points do I need to get out so that everyone can hear them or so they can come out. Now they're out. It's what points are going to come out that I can use in closing, okay? Because you want that second bite at the apple, and you're going to get it in closing argument. When you're writing your cross-examination, when you're coming up with it, you should be pairing off with whoever's doing closing, or have your students pair off with whoever's going to be doing the closing. Now, sometimes whoever's doing the cross might also be doing the closing, but not for every single witness. But you should pair off, because the person who's doing the closing and the person who's doing the cross should sit down and say, what points do we need to get out? Okay, we need to get out that Joe was speeding. The next question you should be talking about is, well, what witness can tell me about the speeding? Well, Mary can do it. Okay, how are we going to get Mary to say that? Well, on cross, you're going to say, what kind of car were you in? Well, I was in a Ferrari. And, how many gears does that Ferrari have? 9. And isn't it true that a reason most people drive Ferraris is so they could drive quickly and not a leisurely drive? Well, yes, most of the time that's true. And isn't it true that you were in at least 4th gear at the time this incident happened? Yes. And isn't it true that 4th gear goes from 55 to 95? Yeah. Okay, so you want to get that information out, but you're going to use it for closing. And when I coached, I always told my students, have one person set aside to keep track of each nugget. When something came out that was good, write it down. Whether or not you're doing the closing or not, write it down and then hand it over to whoever's going to do the closing. I mean, hopefully they're keeping track too. But I always had one person who was the nugget tracker, basically, that kept track of all the good stuff and made sure that whoever's doing the closing got that, okay? Because the scoring judges look to see that you listened during the whole trial. Okay, and I know by the 3rd or 4th round, the last thing you're going to want to do is listen during the whole trial. But honestly, if you're doing closing, you better be listening to every word that's spoken, because something's going to happen that you're going to have to talk about. And that's why, honestly, trial work is such a headache because there is no rest for the weary. Okay, you could be sitting there and you know that this witness that's coming up is just going to talk about nothing. I do mostly defense work, so I certainly don't want to besmirch the name of plaintiff attorneys, but sometimes a plaintiff attorney will call a witness who what they call like a before and after witness. They're a witness that will testify that before this incident, this person was vibrant and could do everything and worked out every day, and after they can't do any of it. It's a fair witness and it's effective, but as the attorney on the other side, you kind of want to go to sleep because there's no cross-examination, nothing you're going to be able to do with that witness, and just let it go. But you have to sit on the edge of your seat through every witness, including that witness, because who knows if they're going to say one tiny thing in the 2 hours they're on there that you can pluck out and in closing say, funny, when the plaintiff's mom testified about what she could and couldn't do, she mentioned bowling. Isn't that weird? They mentioned bowling, but this person says they can't even lift up 5 pounds. Something's going to come out. And the only way you're going to catch that is sitting on the edge of your seat. And the other thing I did when I was coaching is I actually told my attorneys who were doing closing, I want you sitting on the edge of your seat. And I didn't just say that as a funny saying. I said, I want you straight up on the edge of your seat so I know that you're listening. I don't want you sitting back. It sounds silly, but it's going to make you watch and make you listen for the nuggets. Cross-examination is getting concessions, admissions, weaknesses, etc. If you see the direct examination as someone building a brick wall, closing is taking out some of those bricks. You don't need to take out all those bricks, but just like a brick wall, if you can take out enough bricks near the foundation, you can knock that wall over during your closing. Okay? That's part of what you're doing. In closing, don't get cute and ask a question that you don't know the answer to. During cross-examination. You always want to know, or at least have a fair idea, what the answer is going to be on cross-examination. Don't think, I'm on a roll. I'm going to throw out another question. I don't know what it's going to be, but I'm going to say it. Don't do it, because you never know what's going to happen. Okay, so during your cross, don't ask questions that you don't know what's coming. Okay, because you're going to kill yourself. And it kind of goes along the same lines with what Stephanie was saying, is listen to the answers. If you're not listening to what's going on, you're going to bury yourself. You always do on cross-examination. If you're just looking at your script and decide to go to something else, and you're not listening, it's going to come back and haunt you for sure. Okay. Courtroom positioning. For direct examination, all right, the witness is testifying. So you want the jury to look at the witness. So if this was our courtroom, of course this is a courtroom and the witness is here and the jury's here. When you're doing direct examination, it's a good idea to stand at the back of the jury box. Like if I was in this courtroom, I'd probably stand around here. And I'd ask my questions and I'd tell my witness, kind of half look at me and kind of half look at them, because they have to look this way, okay? Because they're testifying. However, on cross-examination, you get front and center because you're testifying, Okay, it's important to know where you're standing in the courtroom. It's important not to, I mean, I like to walk around, but it's important to know what your position is, and you have a position of power. Okay, you're the one that's talking, you have a position of power. So you want to make courtroom positioning important. And for cross-examination, you've got the spotlight on you, you're the star, the witness is nothing during cross. They really aren't. They're the vehicle for you to testify. So get front and center. Don't sit behind the, it bugs me to death. I mean, sometimes you can do direct examination behind the desk and sitting, whatever. But if you're sitting there for cross, it is so ineffective, I can't even tell you. If you sit down and don't stand up for your cross-examination, you just take away half of your power. And you just don't want to do that. Okay, you do not, and Stephanie made a good point about this, you don't need to get every single point on cross-examination, just like on direct. The people who write these problems for mock trial, they intentionally include all kinds of stuff that just doesn't matter. And I've seen students before, they hit every single point. You know, oh, they were wearing, purple shoes that night. Okay, I don't need to know that. No one needs to know that. Well, it's the same thing on cross. You're going to want to get that. So the case is about a guy who almost, attempted murder, and the witness got a D in shop. Well, that might affect on their credibility, so I'm going to talk about that D in shop. Well, you don't need to, okay? Don't get sucked in by these problems and try to make sure that you're going to get every single thing that's on there. Okay, you have to pick and choose. My other favorite thing about what they do and what sometimes students will do is the ultimate question. I love this one. Don't ask the ultimate question. What does that mean? So in a murder trial, the ultimate question would be, well, isn't it true that you killed that person? Okay, or negligence trial, isn't it true that you were the cause of this incident? Okay, this isn't Perry Mason. This isn't, I'm talking about dating myself. It isn't a Law and Order TV show. No one's going to crack on the stand and start bawling and say, yes, I did it. It's not going to happen, okay? So you don't need to ask the ultimate question. You work yourself up to the ultimate question, and then you stop so that you can argue it in closing. The example I like to give is I represent, let's just say for the sake of argument, I represent a client who was sued for biting off the nose of somebody else in a fight. Okay? And I'm cross-examining a witness who purportedly has information that would prove that my client bit the other guy's nose off. Okay? And direct examination went okay for that witness, but they were really vague about why they know. So now I'm ready. So I'm cross-examining the witness, and it's a fight at a school, and the fight happened about 2 p.m. So I said, well, it's your understanding the fight happened at 2 p.m. You don't have any reason to dispute that, do you? No. And you got out of class at 2 p.m., didn't you? Yes. And your class was across the campus, wasn't it? Yes. And then how long did it take you to walk across campus? Well, about 15 minutes. And when you got there, by the way, how tall are you? 5 foot. And wasn't it a fight with the basketball team? Yes. And all the basketball team, they're about how tall? 6'2", 6'3"? Sure they are. So you really couldn't see past them, could you? No. And by the way, I see you got glasses on. What's your vision without glasses? Well, 28,000. Okay, and you didn't have your glasses on today, or the day of that fight, did you? No. So by the time everyone was fighting, everybody was rolling through, you were behind a bunch of tall guys without your glasses, and the fight was almost over. Is that fair? Yes. Stop. Stop and stop. Because now in closing argument, you have just made that witness into nothing. But what everybody wants to do is say, so isn't it true you don't have evidence that my client bit that person's nose off? And what are they going to say? Well, no, I do. Now you're stuck. Now you have to say, well, what evidence do you have? Which is an open question. And of course, the answer is going to be, anybody? I saw him spit it out. There you go. Okay. Don't ask that last question. As much as you want to, save it for closing argument. Hostile witnesses. Let it roll off your back. When you're the attorney and you have a hostile witness, they're not trying to attack you. They're not trying to be mean to you. Don't get mad. Stay calm. Be very zen about it. If you want to put your hands like this, be zen about it. Don't get mad. You don't need to raise your voice. You don't need to get rude. You don't need to slam things. You can say things like, can you just answer the question? Or that question calls for a yes or no answer. Can you please provide that for me? Sometimes you can ask the judge for help. Your Honor, I've asked the same question 5 times, and they just won't give me an answer. Can you please ask the witness to answer my question? Sometimes you got to change your question, okay, when the witness is hostile. Sometimes you have to lay some extra foundation. You have to kind of help them so they'll remember. That's fine. Sometimes you have to impeach them with their own statement. How do you do that? So if you know in their affidavit in the materials they said that the stoplight was red, and on the stand they said the stoplight was green. Now you know you have them, but you can't just say, well, you said that in that written thing, didn't you? No, because you're not going to get any points with that. So what you're going to do, I'm going to go through this slowly. The witness says the stoplight was red, and in their statement they said it was green. I might have made that backwards, but that's okay. So you say, Mr. Witness, do you recall giving an affidavit in this case? Yes, I do. Your Honor, can I approach to show the witness their affidavit? Sure. Walk up, show it to opposing counsel first. I'm going to show them that. Okay. You hand it to him. Say, witness, do you recognize what I've just handed you? Yes. What is it? What's my statement? Well, Mr. Witness, is this a fair and accurate, those are the words you want to use, fair and accurate copy of the affidavit that you gave? Well, yes, it is. Okay, now you can use it because it's the same one they gave and they've admitted that it's the one that they gave. Now, the next step to me is the most important. Make them read it. You don't read it. You don't pull it back and say, okay, so line 5, you said it was green. You've just lessened the whole effect. So you say, read me line 5, because they're the ones that just said red light, and then out of their same mouth, they're reading their own statement that says green light. It makes them look twice as bad. And then you don't need to say anything again. So they're going to say, on the night of the 15th, there was a green light. Don't then say, so you've changed your... You don't need to explain it. Just take the statement back and say thank you and move on. Okay? Impeaching with a statement is going to be really effective if you know how to do it, and it's going to help get a lot of points. Finally, dealing with a hostile witness. Sometimes you just have to move on. Sometimes your witness is going to get the better of you, and they're going to be prepared, more prepared, or maybe it's an issue they're just not going to budge on. You just got to let it go. Don't let it get you angry. Don't let it throw you. Just got to move on, because sometimes you're just not going to change what they have to say. Okay. Slowing down a good cross-examination as the other attorney. Judge Barker might not want to hear this, but sometimes if your witness is getting hammered on cross-examination, you just have to object. I don't care what you say. Objection, relevant. It doesn't matter. Sometimes you have to stop them. If they're a freight train and your witness is just getting punched left and right and about to be knocked out, stand up and yell anything. I don't care what it is. We get a bathroom break. I mean, whatever you want to yell, sometimes you have to stop what's going on. So object to anything just to slow it down. And when you're preparing your witnesses, as I said before, prepare them on how to handle cross. When you prepare your witnesses, and when I prepare my own witnesses for cross-examination, I usually go get another attorney in my office, and I tell them a little bit about the case, and I say, and I won't let my witness know who this person's going to be, even for the second before it starts. I say, someone's going to come cross-examine you, and I pick the meanest, biggest guy we have in the office and say, hey, come in and just get in their face. And they do, and I want to see how my witness is going to handle it, and you guys should do the same thing. See how they're going to handle it. Slowing down a good cross as a witness. Fight to explain your answers. If you're playing the witness, fight through yes or no. just calls for yes or no. Well, it may, but it really deserves an explanation, you know. Especially if you're an expert. I don't know if this year, usually every year, does this year have an expert? Okay. So if you're an expert, you know, and they say, well, you know, isn't it true that that velocity would be 15 miles an hour? Well, it's not that simple, counsel. Or, you know, well, it would be, but not under scientific principles, and let me explain why. Make the attorney have to work at it, okay? If you're the witness, don't just roll over, because that's not fun. That's not part of what we're doing here today and what we're doing for the mock trial. Make it more difficult. Find a way not to say yes or no. Okay. What I wanted to do is, Andrew, did you want to go on the witness stand? We're going to do a quick little, now that I just have a couple minutes left, and then we'll have some questions. Andrew and I are going to do a little direct exam, cross exam, just so you can get a feel for what the difference would be. Oh, sorry, I should have thought of that. So as I said, direct examination is open questions, cross-examination is closed. So the issue that we're going to briefly talk about, just so you can see the difference, is that Andrew thinks baseball is the best sport to watch on TV. I think it's football. Okay? So direct examination. Can you please tell the jury your name?
I'm Andrew Craner.
Mr. Craner, what type of TV do you have at home? I guess I would be standing there, but I don't want to block your way. So what type of TV do you have at home?
Close enough. I have a 32-inch television, I guess HD TV.
Okay. And how often would you say you watch sporting events on TV?
Usually try to catch a game, usually every Saturday and Sunday if it's on in prime time.
Okay. Do you sometimes watch Thursday night games also?
I sometimes do if I'm out with my friends at a bar.
Okay. And so how often would you say you watch sporting events not at home but maybe out at other facilities like a bar or other place?
On average, maybe once or twice a month.
Okay. So watching sports on TV is something that you say do on a semi-frequent occasion?
Yes, I would indeed agree with that.
Okay. And what do you think the best sport is to watch on TV?
I think the best, well, I'm a big football fan. Is that the one?
Or you could say baseball if we wanted to go with the theme
I
of what
forget
we're
which
doing
one.
today.
I forget you were. I forget. If I was baseball. Yes, of course. Well, I'm trying to get my sports right. No, anyway. Well, every spring I look forward to not just the weather changing and not just the clock changing, but also for baseball season.
Okay. And so, can you tell the jury why you favor watching baseball over other sports on television?
Because I think you get more of your money's worth. There are, after all, 9 innings and 3 outs, and you just get more of it. You get more of the game.
Okay. All right. Now let's play cross-examination because he's already told his story. He told you why baseball. Okay, he's got that out. So now cross-examination. Mr. Craner, although you favor baseball, you have seen football on TV, haven't you?
On occasion, I have.
In fact, earlier you got so excited about it that you said football instead of baseball, didn't you?
I did because I was trying to keep worse. Yes, I did.
Now, other than perhaps a player sliding into another player, you would agree, wouldn't you, that baseball is not a contact sport?
No, I think there is. There's definitely a very aggressive contact with the bat, and hitting the ball. I've seen it where a player's nose got injured. I think there is contact with the baseball.
Well, let me try to be more specific. Would you agree that tackling of another player in baseball is frowned upon?
I don't know if I would necessarily agree with that, counsel, because in baseball, he's throwing after the ball's been in the field, he's trying to throw it to the second baseman. The second baseman is going to try to virtually tackle him with the ball. I think there is some contact in baseball.
Do players in baseball have to wear pads because they get tackled so often?
There's some padding.
Okay.
Because they slide into second or third base.
What about helmets? helmets the entire time in the entire game?
Well, I don't know if those caps are really helmets, but I think those helmets are pretty padded. I mean, you can get hit also by a foul ball.
You ever seen anyone tackle a pitcher? Other than in a fight.
I've seen. I've never seen them tackle them, but I have seen them, kind of make a run for them with the baseball. I mean, they're, after all, they don't want the baseball to get thrown up to the stands and have some little kid little kid catch it and say, now the baseball's out of the game.
Andrew, just between us, guys like to see pretty cheerleaders when they're watching games. Don't you agree?
Oh, absolutely.
Baseball doesn't have cheerleaders, do they?
No, but they're very pretty.
It's a yes or no question. Do baseball have cheerleaders?
No, they do not.
Okay. So what happens in a baseball game when it rains?
They do. I actually have been to a couple games where it was drizzling, and they said, we're still going to play the ball today.
Have you seen a baseball game that proceeded in the snow?
No, because I don't usually. No, I have not.
All right. And whether that wouldn't disrupt a football game, would it? In fact, football games are more fun to watch when it's snowing. Wouldn't you agree?
Yes, that makes it definitely much more exciting.
In baseball, isn't it possible that a player might be in the field and not move for an entire inning? Say, for example, if a ball isn't hit to them, like a guy in right field.
That is true, because I know as a matter of strategy that they don't want to move to the next. They don't want to run to the next base until they have a clear shot of not getting tackled. And
in football, every player's moving on every play, aren't they? Or else they're going to be on the ground, right?
Yes, there's definitely more movement in football.
Finally, Mr. Craner, and I know this probably isn't a fair question, but has Bruno Mars, Beyonce, Madonna, or Black Eyed Peas ever given a concert during a baseball game?
No, but I think. Well, I'm sure the Peas took several turns at the national anthem. I mean, one P would do one verse and the other P would do.
Okay, that's enough of that. Thank you. Okay. By the way, did anyone think I needed to ask more questions about the tackling issue on cross-examination, or do you think that perhaps it was a good example of something I didn't mention earlier? Is sometimes if your witness is trying to get around a question, and they say something that's ridiculous, nothing against you, Andrew, but they say something that's ridiculous, you really don't have to keep hammering at it because you can do it in closing. All right, so in closing, I'd have said, he was trying to say that they tackle in baseball because a ball hits a bat. That makes it a physical sport. And, you can argue it in closing. You don't always have to get that answer. But Andrew obviously did a good job of trying to dance around what he didn't want to say. All right, does anyone have any questions? I know we kind of ran through cross-examination very quickly. Does anyone have any questions they want to ask about cross-examination issues? Yes, ma'am.
Okay, so for the cross-examination, I switch it up and say, you killed the person, didn't you? We don't have to lay foundation for that in cross-examination?
No. Now, that would be an ultimate question, like I said before, but you don't have to lay foundation. You got to be careful if you don't know what the answer is going to be, but a better example would be if it's a case where someone was speeding, instead of saying to have that first question be, well, you were at fault, weren't you? You could say, if their affidavit says they were going over 55, you can make that your first question instead of when you prepared the first time and it was your 50th question. Okay, you could say you can go backwards and lay the foundation. So let's say, for example, the witness is on the stand and you say, for the very first question, you just pop up and say, well, on the 15th, you were going over 55 miles an hour, weren't you? And they say, well, yes, I was. And then you could back up and you could say, well, let's back up for a second. You were driving a car, correct? Correct. You know what I mean? You can lay the foundation after. What I'm saying is sometimes it's fun to hit with a right hook at the beginning instead of just soft punches, especially on your third or fourth rounds when we've heard the same thing over and over and over. Yes?
So you don't have to go in order, but you can just go back and forth?
You can do whatever you want. You're testifying. You're the attorney's testifying on cross. You can do whatever you want. All right. I mean, within boundaries, you can pretty much do it whatever order you want, and that's one of the things I'm telling you, especially in later rounds, you're going to want to do. Anybody else? Okay. I think at 10:30 to 10:45, we're supposed to have